Labor union extraordinaire versus the Department of Labor. They're attacking DOGE. Why are you suing? The president has executive power and the authority to make executive discretionary decisions to manage the executive. The labor union have failed to establish standing. What are you suing for? WAP standing. Get out of here. They freaked out. They sued. They moved for a restraining order, the unions. What's your injury? You got fired from a job he's allowed to fire you from? All right. Your motion for a temporary restraining order at the Department of Labor is denied. The DOGE battle continues. We have some victories and some setbacks, some delays. We're going to see where these ultimately go. But of course, remember, we're dealing out of the District of Columbia, and we know how perverted this jurisdiction is when it comes to the law. This is a victorious one that came out from the District of Columbia, and it was brought by the AFL-CIO, Labor Union Extraordinaire versus the Department of Labor. They're attacking DOGE, and this was a little bit of a preemptive strike. We know that DOGE has been going into USAID and Treasury and other entities, and they're freaked out over that. But this is a victorious one because the judge recognized, they said, who are you people? Why are you suing? The president has executive power and the authority to make executive discretionary decisions to manage the executive, as has always been the case. And now you're just a labor union. You're coming in and suing like you have a right to not be fired or something. What? The judge wrote this, and this is from the District of Columbia. Says, all right, look, the plaintiffs here are labor unions and a think tank. And they're suing to get into the Department of Labor to stop DOGE and to restrain DOGE, which was previously known as the United States Digital Service. Okay, got renamed. Now it's the United States DOGE Service. It was already allowed, already appropriated by Congress. It's existing. It exists. And the United States DOGE Service Temporary Organization from providing any person outside the DOL, the Department of Labor, most pointedly, the other defendants' employees, here in this case, DOL, Department of Labor employees, with access to non-Department of Labor information or data, and from requiring the department employees currently existing there from giving Elon's people the info or the data. This data includes the medical and financial records of millions of Americans. But on the current record, they say, the judge, the labor union have failed to establish standing. What are you suing for? WAP standing. Get out of here. So although the court harbors concerns about the alleged conduct, you guys have no standing at this time. Here's the background. On February 5th, the labor union and 4 of its affiliates and the Economic Policy Institute filed this lawsuit. They wanted a restraining order. They wanted to stop DOGE from getting into the Department of Labor, saying that DOGE is going to access core data, and it's very sensitive data, and they can't. Plaintiffs allege this would be unlawful because, first of all, they say the USDS, the DOGE service, lacks legal authority to take these actions, and the department is required under the Privacy Act to get approvals before sharing records with another agency or person. So the judge says, all right, well, let's go into the background here. On January 20th, Trump was inaugurated to his second term as president. The same day, he issued the DOGE order. Now, as a technical matter, the order renamed the digital service to the DOGE service, as we covered when we read the executive order, and established the service within the executive office of the president. Now, DOGE's mission is to modernize federal technology and software to maximize efficiency and productivity. So the new USDS consists of 2 parts, the DOGE Temporary Organization and the DOGE Teams. It exists for 18 months. The temporary service is headed by the USDS administrator, who reports to the White House Chief of Staff, dedicated to advancing the president's 18-month agenda. Now, DOGE Teams, in contrast, are housed within other agencies. The executive order requires each agency head to establish within their agency a DOGE team of at least 4 employees, right? And this was like the interoperability agency. So Obama set this up to interface like the IT department with all of the different executive branch agencies. You can think about it like the DNI, the Office of Director of National Intelligence, who was now created as an agency to interface with all of the other intelligence agencies like the CIA, FBI, NSA, and all of, the Army secret, and all of them have their own secret agencies. Like there's 19 of them, or maybe 18 plus DNI. So the 4 team members may include special government employees hired or assigned within 30 days of the order, but in any event must be chosen in consultation with the administrator. Agency heads are obligated to ensure that the DOGE teams coordinate their work with the main agency. So in recent days, although the judge says when exactly is is unclear. They say 4 USDS DOGE service employees have been detailed to the Department of Labor to, quote, assist the department with improving its information technology and data organization systems and in obtaining accurate and complete data to inform policy decisions. Now, the DOL, says the judge, contains many bureaus and agencies. In totals, it houses data in over 50 systems. It says the labor union points out 4 divisions of the department with sensitive data: the Compensation Act claims, which is worker claims; Wage and Hour Division, which enforces labor standards; OSHA, which enforces occupational things; and this other entity, BLS, Labor Statistics, which collects data. So on February 4th, DOL leadership reportedly told its employees, including an unnamed DOL labor employee and member of the union, that the DS would be accessing the headquarters at 4 p.m. on February 5th. This guy, Rushab Sanghvi, says, oh, well, these guys are coming in. The department leadership ostensibly came with an instruction to department employees, do whatever USDS asks. They're coming in, they're looking at your systems. This included providing access to any requested department system with regard to security protocols as well. So in light of the above, they freaked out. They sued. They moved for a restraining order, the unions. The unions sought relief, saying that they're going to come in and access the data. The court, however, postponed the ruling based on the representation by the government that labor would not give them access to any department data before the motion. So the court scheduled this to hear, and that's why we're here. So the judge says, okay, look, here's the thing. The standard for this issuance of a restraining order is usually an extraordinary and drastic remedy. Okay, it's a serious thing. Like you're stopping a government for doing a thing that it's legitimately allowed to do. So if you're going to impose a temporary restraining order, you must demonstrate the following: a substantial likelihood that you're going to win, that the moving party, in other words, the unions, would suffer irreparable injury, that this order would not injure anyone else who's interested in this, and that the public interest would be furthered by the injunction. Here they say, well, let's begin with the first prong then, whether they're going to win on the merits, saying you can only sue in federal court if you have an injury in fact. Let me back up. The first component examines whether they have standing. Okay, so we have to go back to standing. This is a key point that I almost skipped over. A plaintiff may only sue in federal court if she has an injury in fact caused by the challenged conduct and redressable by the relief requested. Standing. We saw this a lot here in 2020 when people were suing the government saying, I'm being injured. We were watching it and we were going, oh man, yeah, it's suing over the election, right? But what was the injury? And the injury was that the election was stolen. And well, how do you specify that to that person specifically? So then we had to go find Trump as a plaintiff, right? Or electors as plaintiffs. It's not just regular voters as plaintiffs who are upset about the operation of the government. So they got all dismissed on standing. So same thing here, essentially. What's your injury? You got fired from a job he's allowed to fire you from? All right. He's giving access to an entity that he controls under the executive branch. What are you so upset about? When seeking a restraining order, at least one plaintiff must demonstrate a substantial likelihood of standing. That means that a plaintiff, in this case a union, cannot rest on mere allegations, but must have specific facts that, if taken to be true, demonstrate a likeliness of standing. Now, organizations like we have here, we've got a union and a think tank. They've got a couple ways they can do this since they're filing as organizations, not individuals. You can say that their members have been injured, or you can say the organization have been injured. Now, you say that you've satisfied both, but the judge says, you haven't. On the present record, you guys satisfy neither. You haven't shown you have standing at all. Associational standing requires that an organization show its members would otherwise have standing to sue in their own right, like each person could sue individually, that the interest it seeks to protect are germane to the purpose of the organization, and that neither the claim asserted nor the relief requested requires the participation of individual members to the lawsuit. So for the first requirement, the unions did put forward some evidence of their members that they may suffer injury because of this conduct, saying, you guys say that the DOGE access to the labor data, you say, will harm millions of workers and their families because it will result in unauthorized access to sensitive data. There was a declaration saying if DOGE is allowed to access these claims, highly personal information will be disclosed in violation of their privacy interests. They also assert that the data sharing will chill their members' willingness to raise complaints at the DOL. But they say, however, look, if you want standing here, you need more than just generalizations about the organization's members, you must point to a particular member and establish that she would have standing if she came here alone. Other cases support that. It's not enough that 3 of the general counsels submitted declarations that the members will be harmed, like the lawyers are saying, no, they will be harmed. If one of the plaintiffs is to have standing, it must be organizational. That requires that the organization, like an individual, show an actual or threatened injury in fact that is fairly traceable to the alleged illegal action and likely to be resolved in court. It cannot simply be a setback to your abstract social interests. It must be a concrete and demonstrable injury to your organization. In other words, you must allege that the conduct impaired the ability to provide services. So courts in this circuit first ask whether the agency's action to act injured or will injure the organization. Now here, you say they will be irreparably harmed if they cannot ensure worker privacy. And there's much more in a declaration that comes out. Now, if the department shares information with unauthorized individuals, you say the trust will be broken. You say it will have a negative impact and that you will be harmed. Now, regardless of whether or not this adequately shows the conduct would actually injure you, you run into an obstacle, which is the second requirement. Now, nowhere does the record state that the unions or any other plaintiff here will use its resources to counteract the harm caused by the conduct, nor does any plaintiff's motion even allege any of them will divert resources. But DC precedent clearly requires both a harm and the use of resources for organizational standing. Interesting. The record here is simply insufficient to this point. So in other words, they might amend their complaint and refile, but right now they don't have standing. So they'll go back and find somebody who was actually harmed. No, this person is going to be harmed, right? Or if this happens, like specifically this person, they'll go drag someone out. And then they'll say, this is what we'll do to counteract the harm as it stands. They haven't done that. In some, plaintiffs fail to establish that any one of them has standing under either route. That means they're not entitled to relief right now. Sorry. And so for the reasons here, it's ordered that your motion for a temporary restraining order at the Department of Labor is denied. It is further ordered that you shall file a preliminary injunction briefing schedule not later than February 12th, signed by John Bates. So that is a setback for them, and I'm sure they'll amend it, right? They're going to take many bites at this apple. They're going to just keep lodging these things. And eventually we're going to have to take it up outside the Court of Appeals, up to the Supreme Court on many of these issues to have the executive branch push back and reestablish its power that has been minimized because it's been playing patty cake with Congress over the last several decades.